Yeah, should we start?
Yeah.
Hello. Give me one.
Yeah.
Yeah,
Sure.
go on, start. Yeah.
Hi everyone, I'm Neha Shetty, a fourth-year student at Hidayatullah National Law University and one of the core committee members at Progressive Constitutional Law Society HNLU. It's an exciting time for us here at PCLS to be hosting our mentor, Mr. Gautam Bhatia, who is like one of the primary reasons behind the founding of this society. So we're very excited for the reading circle that's going to happen today. Most of us have read the articles sent across by you. And without further ado, I'll call upon you to begin with the reading session. So over to you.
Yeah, thanks a lot. No, so I think that with these reading circles, what's helpful is since all of you have done the readings, we don't need to kind of like describe the readings or anything of that kind. So what I'll do is I'll basically contextualize the readings and why I thought it might be helpful or good to read these readings specifically right now, and then we can just jump into a discussion straight off, which I hope will be led by you all. So I want to focus on the Amy Kapczynski piece, Right to Medicines in an Age of Neoliberalism, and kind of the Corey Robin and Alex Gourevitch pieces, in a certain sense, kind of giving you a bit of a intellectual framing of the core argument that Amy Kapczynski actually makes in her piece. So, like we focus on that piece, and to the extent that insights from the Corey Robin piece are relevant, we can bring them in as well. So, I mean, the major reason why I wanted us to read this today is because a couple of things actually. One is that there's been so over the last like 3 or 4 years, specifically litigating, practicing in India before the Indian courts, right? Human rights have become kind of a very big deal because the present government kind of pushes boundaries with respect to what the Constitution allows or requires. So it's been a constant stream of cases involving civil rights, human rights being litigated in courts and so on. And so there's kind of a sense that to stand between the individual and the state in a way that protects individual rights, the human rights framework is of critical importance, and it's indispensable as a tool, as a terrain, as a platform to hold the state to account and to ensure that individuals are protected. That's kind of the sense of that has become particularly acute, I think, over the last 3 or 4 years, over the last few months specifically, especially in light of all the things happening after the CAA protests, and that's very important, and it's very important to focus on those issues. It's very important to agitate for basic civil rights at all times against the state. That's extremely crucial, and it's important to kind of study that, practice that, be in courts, write, argue, all of that. That's one thing. At the same time, we have a long-standing human rights discourse that goes far further back, and that's not so much to do with civil rights, political rights, it's to do with socioeconomic rights through the mechanism of public interest litigation, PILs, and so on. Right? That tradition goes back to the 1980s, the last 4 decades, and what we have seen over the last 4 decades is that the language of rights and the vehicle of rights has been the chosen discourse in which those kinds of claims, socioeconomic claims, have been made. And I'm not even now referring just to quotes. I'm referring to the language in which we talk about these issues. The right to food, the right to livelihood, the right to education, the right to environment, and so on, right? So we speak about these issues also in the language of rights as claims that we make upon the state, sometimes upon other private parties, and as claims that can be enforced through the vehicle of litigation, either through judgments or even through kind of a dialogue between the courts and other institutions, through nudges and things like that. But we come down to the basic idea that that what we have is the Constitution. The Constitution gives us rights, and that's what we need to enforce. Now, I think that it's important to be skeptical about that way of framing things. And and this is not the same thing as being skeptical about PIL. Right? That's a different debate altogether. That's a different issue, and there can be discussions on what PIL has become, what PIL is. That's all fine, but there is a deeper level critique that we need to be aware of and to engage with, and that deeper level critique is that it's not about the way PIL has evolved in India specifically, but it's about how framing these issues in the language of rights can often not merely be futile or pointless, but can actually serve to entrench the very inequalities and problems that we are trying to redress. And so often we may think that we are doing good and benefiting people by making claims on their behalf that we frame in the language of rights. But actually what we are doing is further helping to entrench the systems that allow for those rights to be violated. Right? That's basically like the key thing we need to engage seriously with. And this is something that is not at all engaged with in law schools right now, because the human rights discourse is taken as a universal good. And the debate always has been, okay, like human rights are a good thing. The state can restrict them in certain occasions. So our entire fight, our entire debate is like, how do we manage to draw that line that can, reconcile the importance of human rights with the state's power to restrict them for the public good. And whether you're like liberal, conservative, it all comes down to that debate, right? Like, where is that line to be drawn? What's allowed and what isn't? And this deeper critique actually says your entire debate is misplaced, because wherever you draw the line, you're using the wrong vocabulary to try and get what it is that you want. And to understand that, you need to understand that that the law is not a self-contained domain. Right? We are taught law as if it is a self-contained domain, but law is embedded in a large number of other domains in society. And the domain that we are interested in particularly here is something called political economy. Political economy is a phrase that was in vogue in the 17th and 18th and 19th centuries. And it broadly refers to the politics of how you organize your economy, right? So you can see political economy, right? Just like break it down into its two component terms. And the basic idea is that that the question of how you organize the economy is a political question. And so Karl Marx wrote a famous book called A Critique of Political Economy, and Adam Smith, David Ricardo, those famous names you would have come across in Econ 1, frame their arguments as questions of political economy. Sometime around the early 20th century, mid 20th century, this idea that this question is a political question kind of went out of vogue, and instead you had economics, right? So the idea then became that there is a science of economics, right, which has to do with the assumptions that there are scarce resources, right, and they have to be distributed or allocated in certain ways, and what is the mechanism of allocating those resources. That is the science of economics, and those answers have those questions have mathematical answers. So you can, if you make the right assumptions, you have the right mathematical models, you get answers to economic questions. So political economy went out of fashion, and economics became the branch of study that everyone engaged in, and that's something that's continuing today. So I'm sure in your law school you have had an economics course, as everyone else does all over the world, but there would have been no reference to political economy as a discipline. And it's quite interesting because political economy was how people referred to it right for centuries, 2 or 3 centuries up till the mid 20th century, and then it's just disappeared because of the attempt to push these questions outside the scope of consideration, and to depoliticize economics, right? So that was the idea. And so now you have a return of that question. So the law and political economy movement in the US, whose blogs I've often shared, and one of whose founder members is Amy Kapczynski, who's the author of this piece, is getting those questions back into the public domain. And what they call their enterprise is law and political economy. So you have to understand both law and political economy to understand these issues and understand how questions of political economy are coded in and through law. And so you can't simply be a human rights lawyer if you want to advance the claims of equality, freedom, and so on. You have to also be a political economy lawyer, and that requires being well abreast or being familiar with legal domains that you may not think have to do with human rights or public law, but actually have a lot to do with how the economy is politically organized. And these include, for example, intellectual property as like core issue, and that's the topic of Amy's piece. They include corporate law, because corporate vehicle is a fundamental method by which modern society is organized. The limited liability as a legal concept, which we would have studied in Corporate Law 1, was a fundamental reorganization of how legal fictions or legal personalities could intervene into crucial questions of distribution of resources. Trusts are like another vehicle that does so. So you can see how suddenly like it's no longer a question of constitutional law and like fundamental rights, but to understand them, you have to understand these other really core, what you think of as private law domains, because a lot of action is happening over there. And what Amy's piece does is that it really brings the two in conversation. And so I'll just like briefly flag what her point is, and then I think we should immediately move into discussion. So the point that she basically makes is that you approach the court, right, for a right to health. Right? You say that, look, I as an individual have an enforceable right to health against the state, and the fact that medicines are out of my affordability range is a violation of my right to health, and therefore you, the state, has to do something about that. Right? That's your claim. It sounds like a very logical claim, as long as you accept the premise that there is a right to health. But then what she points out is that the reason why the state is unable to actually provide you that medicine at affordable rates is not because it doesn't want to, right? Or because it's like keeping something back. It's not like a free speech case where the state is censoring you, right? And to free up your speech, you just have to strike down a law, or like basically the executive has to stop like muffling you, right? It's not that simple here. But the reason why drug prices are high and you can't access drugs has to do with an entire political economy that includes law, but is not limited to it. And this political economy includes a whole host of component moving parts that include pharmaceutical companies, the funding of pharmaceutical companies, the law of patents that allows pharmaceutical companies to exert a monopoly over the production and distribution of drugs, and therefore to control the price at which they are distributed, and a series of international treaties that basically prevent individual states from altering their laws to make them more equitable, because then they would be in breach of the international obligations towards transnational investors. Right? And so when you go to the court and say, look, I have a right to health and give me medicine, and even if the court gives you that medicine, so there was a Delhi High Court judgment from 3 or 4 years ago, which you might remember reading about orphan drugs, right? And so this person went to court and got basically got an order saying that, look, the state has to give you this particular orphan drug. Now, if you think about it, an orphan drug, right? The reason why orphan drugs are like effectively not easily available, right, is precisely because the structure of incentives that frames drug and medical research based upon the patent system does not incentivize companies from investigating diseases whose cure will not be profitable, right? And you see this right now in this whole COVID-19 thing, right? There is this massive push towards the COVID vaccine. And if you've been reading some of the articles, what has happened is that because of this massive push towards a COVID vaccine, they're basically neglecting other diseases, right, that do not affect rich people as much, including tuberculosis and things like that, right? So the structure of incentives that determines what research you do into the production of drugs. A political economy question that is framed by patent law and things like that, right, ensures that orphan drugs aren't available. And so when the court basically forces the state to give it to you, right, you as an individual will get a drug, but that's not going to solve the problem of access at all, right? And so then the question to be asked is that, are we barking up the wrong tree when we frame the issue as an issue of rights? Because it's not just me enforcing my right against the state. It's about how we've organized the economy to ensure that those rights cannot be vindicated by the action even of the state. If you think about this issue and in a little more detail, right? So what therefore comes across, right, is that the actors involved are manifold, and they're not just the state and the individual. And the logic that they operate with is not just legal logic. Now, a little more background context here, and then we go into discussion. There's a very interesting book by the author Quinn Slobodian called The Globalists, where he traces the development of the economic logic that we now call neoliberalism, right? And his basic point is that the purpose of all of this logic, right, is to encase, the word he uses is encase, to encase the market economy from democratic demands, right? So basically you are insulating the market economy through the law, through legal methods, to ensure that democratic decision making cannot overturn that logic, right? And so when India, for example, signs up to an international treaty like TRIPS, right, which obligates it to bring its laws in line with the TRIPS standards, what it ensures is that the Indian people, acting either through their elected representatives or the Indian Constitutional Court applying the Indian Constitution, cannot overturn that market logic. Because if it was to do so, then the Indian government would be sued for like millions of dollars, which is happening right now in many investor-state arbitrations. And the amount of money India will have to pay up in those arbitrations will basically come from the taxpayers, like, pockets. And it'll ensure that in any case, then you can't use that money for social democratic purposes. So either way, you're caught in this kind of cleft stick. You can't change your laws because they're determined by your international obligations. If you do change them, either through your judicial process enforcing rights or through the popular demand, then you only have to pay money that you would otherwise have used to kind of guarantee these rights. And so then you can see kind of like the limitations of the language of rights to actually accomplish those goals. And the use of the language of rights then also has the function of obscuring what the real issue is. Because then we all think of the issue as being about rights, the state not giving me my rights, and me going to court to get my rights, and the court either failing or like succeeding in getting me those rights. But the deeper question that's entirely obscuring is that the reason why I'm not getting my rights doesn't have to do with what even my state or my court can do, can accomplish or give to me. It has a much deeper root that has to do with the way we organize the political economy. And so the piece is about how we might, in some cases, be able to use this language to get something, and how often we don't. But the key issue is there is to remember that therefore the language of rights and the vehicle of rights is not an unvarnished good, right? It's something that we should think of strategically. So in some cases and in some forums and in some ways, the language of rights can help us to move towards our goals. But in many cases, that language might be counterproductive because it obscures the real power relations that are at play there. And then we have to push back against the language of rights. So to say that, look, this is not a question of rights, this is a question of political economy. And so our struggle has to be at that level. And I think once we understand that, then we'll be a lot more circumspect about how we approach the Constitution, the idea of rights, courts, and what this entire, what our legal training can actually enable us to accomplish. So that's basically the context of this reading and why I wanted to have us read it. With that done, I think we should get into the discussion, your ideas, your thoughts on the piece, on Corey's piece as well, if you think that has to do with the arguments here. So yeah, I mean, I'm done. Whoever wants can start off.
I had a question, so I will begin. Later on, people who have questions, you can put your names on the chat so we can follow that way.
Yeah.
So, sir, in the article, it was mentioned that there are a few flexibilities given in the TRIPS agreement, which allows for countries to maybe use the tools of compulsory licensing to do away with the strict TRIPS agreement that they have agreed to. So why don't countries employ that? Do you think the informal weapon of trade sanctions lies over their head, and that's why they do not go into compulsory licensing and going into the overall reduction of prices of medicines?
No, so that's a really good question, and it speaks to some of the issues that are discussed there. So no, it's not trade sanctions so much, because as long as you are legally using the exceptions that you are being given within the TRIPS, no other country can impose sanctions on you, because then you can take them to the WTO and of course WTO is right now defunct because its appellate body has been completely taken out. But it's not about trade sanctions. It's more a question of, so for example, the USTR, the US Trade Representative, right? He has this thing called a 301 report, where every year they list countries that are not complying with the best standards of IP protection, and that's kind of like a blacklist, and that blacklist then serves to for other, say, rating agencies to downgrade your ratings. It serves as a disincentive for foreign direct investment to come into your country, and so you have this whole host of, as you said, informal pressures that prevent individual countries from being able to effectively push back against the global regime, which is why the original point I made was that it's very hard for us, unless of the US, whose ability to print money, because the dollar is kind of like the international currency of exchange, enables it to get out of many of these traps. Unless you're the US, you become bound in what is a global logic, because if one country tries to escape that global logic, then it will lose out on a number of domains involving investment and so on, that will then ensure that the government is kicked out and loses power and so on. And so for that reason, everyone has to essentially play along, which again shows you that the language of rights and this whole discourse has to be internationalist now. It can't be at a national level. So I mean, there has to be a pushback against something like the intellectual property regime or the trade regime. It can't happen inside one country. It has to be like a collective pushback at the international level, and that's again something worth noting, because again, for example, when I was in law school way back, international arbitration was like this big kind of thing where people used to say, I'm going to go into international arbitration, right? This was like this glamorous thing that people used to I'm sure they still do. There's like a huge deal, right? Now, what is international arbitration? International arbitration is, for example, Cairn International, saying that when India amended its tax law in 2012, retrospectively, to ensure that tax dodging, which happened rampantly in the 2000s, was curtailed. That is a breach of its obligation to investors, and therefore India has to pay $7 billion compensation. Right? That is international arbitration at its purest form, and you have 3 corporate lawyers in The Hague deciding that case. And so you have to see how that logic operates at this transnational level, and so now within that community, right, you now have pushback where many countries have now begun to opt out of the BIT regime. India is a model BIT now that specifically takes tax disputes outside the jurisdiction of investor-state arbitration tribunals. So you have a kind of collective pushback against ISDS, the ISDS regime, which shows you that in that domain, a collective pushback can work, but it can't be a lawyer inside a country going to that country's court and saying, look, something like our constitution is being like superseded to do something, because neither you nor the court can actually do something about that.
Ayush, you can.
Hi, sir. I had a question. So you were talking about how there's a need to develop an internationalist outlook to things like patent of medicines in general. Don't you think it's curious that these pieces, like Amy's piece and all the responses, are written by Western scholars, and they do not deal with the fact that this problem can be dealt with in the States too? I mean, in the lead piece, they say that how the strategy should be employed in Brazil, in Colombia, and the rest of the responses sort of so have a very positive take on how India has been, giving away compulsory licenses. Yeah. So the fact that in the States they haven't been able to do something like that. So for example, with this vaccine, with the COVID vaccine, or the treatment remdesivir, a lot of it is coming out from the research into Ebola, which was primarily funded by the government.
Yeah.
And so why is it that these academics never talk about the fact that they have not been able to, create that sort of discourse in the West, and why is this blame or this responsibility always pushed onto the global South that you...
Sorry, I lost you for that. I lost you for a moment.
Am I audible? Yeah.
Yeah.
That you guys have to make sure that the regime needs to change by, granting away more compulsory licenses and taking countries and risking that a country like US take you to WTO. So I just wanted to know what your take on that is.
Yeah, no. So I didn't read Amy's piece as asking the global South to like take on obligations that that it cannot or is unable to assume. So I think she herself is like pretty clear that the root of the problems is in countries like the US, and a solution has to obviously begin from there. No, I think I would frame it a bit differently. It's basically that the reason why an internationalist solution is required, and I think this is less to do with which country has to step up, and more to do with the fact that it's not possible for any one country, whether in the global South or the global North, barring possibly the US, to be able to accomplish any of this, because of the fact that the forces arrayed against you are beyond an individual state's power to alter. Right. So as I said, again, take simple examples of the BIT investment issue. Right. So like the way once you sign on to all these treaties, you become obligated to abide by the dispute resolution mechanism that they prescribe, and that mechanism is structurally biased towards a certain market logic, because the very concepts of fair and equitable treatment, the very concepts of the most favored nation clause, basically require you to alter your domestic laws in order to ensure a legal climate in which a foreign investor can invest, even if their interests are opposed to the interests of your own people, right? And if you try to vindicate the interests of your own people, then you can be taken to a foreign court where your constitution will not be applied, but the logic of the treaty will be. So I think the argument is more that global North or global South, you can't change this logic on your own. And just on that is, again, in Quinn Slobodian's book, there's a very interesting thing he recounts, that in the late 60s, when there was this wave of decolonization in Africa, many African countries became independent. So there was, and some of you may have studied this in international law, there was this whole idea of something they call the permanent sovereignty over natural resources. The idea was that every state has the sovereign right to decide how its resources are to be, disposed of for the benefits of its own people. The whole Suez crisis from the 50s has its root in attempts by newly decolonized countries to exert authority over their natural resources. And so these newly decolonized countries, along with India and other states, basically got together and created something called the New International Economic Order, the NIEO, which was very consciously meant to push back against this global neoliberal logic of encasing the market beyond democratic oversight. And Slobodan then shows how through the 70s and 80s, there was this determined kind of fight against the NIEO, led in bodies like the IMF, the World Bank, and so on, until finally they effectively defeated the NIEO, and then nobody now even knows about it, and nobody studies it. So you have to place this kind of in the entire historical context of how there have been previous attempts to try and have this pushback, and whenever there's been something that's come close to succeeding, it's always been through an nationalist alliance. It's never been through like a single country's effort. And so I think that's where kind of like the argument is coming from, the recognition that it can't be done through or by like a single state acting alone. It has to be at the same level at which the treaties exist, the international jurisprudence exists, the tribunals exist. It has to be at that level to kind of like counter that influence. Also, by the way, like it need not be like a Q&A. It can also be like, people can jump in and like respond to questions, have their own thoughts on questions, and you can do it like that as well.
Yes, I have a point.
Yeah.
Yeah, so the solutions which have been given in Amy's piece were not very exact. Like she wants price controls or compulsory licenses. Yeah. So the entire big picture is not there regarding the solution of what should be there. Just the focus should be political economy and not human rights. So I wanted to ask if you think that this is moving us back from the neoliberal logic to nationalizing the industries, particularly the medical industry. And do you think that it is effective to initiate innovation in medical industry?
No, so I don't think it has to do with nationalization so much as a specific solution, right? So if you read, so Amy has another piece on patent where she basically goes into this whole logic of patents as a specific tool of innovation, and finds that on its own logic the argument fails, and proposes other regimes like a prize-based regime and things like that, which can actually spur innovation even more than a patent regime. So if you want specific solutions, you'll have to go to a different piece. That isn't the task of this piece. And alternatives to the existing patent regime, so that you'll find in her other work. I think the basic point here is to I think just kind of shift the discourse a little bit, and to point out that it's kind of the beginning of a conversation, to say that look, if you go to a court with a rights-based claim, A, it'll be limited, and B, as you just pointed out, you're going to run up against a series of economic arguments. So if you go to this whole free-testing issue, right, in this whole COVID-19 Supreme Court, like the free testing issue that happened in Supreme Court. So what happened was, on the first date, the Supreme Court passed an order saying that COVID testing has to be free, right? Then a bunch of lawyers representing these private labs come and say, look, if you make COVID testing free, right, then the labs will stop testing, because they will not get a return on their investment, and so what you will have is fewer tests, and the fight against coronavirus will go down because you'll actually have fewer tests. And the court immediately backs up and says, oh, actually no, free testing only for like people below the poverty line, and has some then useless directions passed on that. But that kind of shows you the limits of the rights-based framework, because what ultimately the argument comes down to is that a rights-based claim cannot defeat an economic argument, because there is a certain inevitability about an economic argument. That this is how things will work. So if the court does X, then the consequence will be a harmful Y that will ensure that overall it's a bad outcome. And so what Amy is saying is, look, you need to tackle the argument at that level, right? So why is it that private labs will go out of business if this specific test is made free? Like, what is the economic model we have chosen that makes us depend upon this particular way of testing in this infrastructure? So if you tackle the arguments at that level, that's where the real debate is happening. And that may show you that ultimately this particular fight is not a fight you can win with the language of rights or in courts. And so if you actually go to court with that claim, it will be damaging, because what happened in this case will keep happening. Another interesting case of this kind is copyright, right? So in the whole DU photocopying case, right, which you may remember from 2015, there was this whole issue of the fact that people were using course packs in DU and to photocopy the prescribed material. So all the publishers sued the photocopying shop and DU, saying that, look, this basically ensures that we have no incentive to keep publishing books. Now, what you can do is you can go to court and say, look, I have a right to education, and textbooks priced beyond my affordability range deprives me of my right to education. To which the counter response then comes is that, okay, but if you don't have copyright protection, right, then publishers have no incentive to produce textbooks. So there will be no textbooks to start with. This whole thing of you have to have the pie to divide the pie, right? That's the whole kind of classic market logic there. And so you can keep making arguments on your right to education, but if the other side says that, look, your right is useless because there will be nothing to access, right? Then you can't win that argument. And so this piece and the argument in this piece is kind of trying to draw attention to the fact that there are limitations in human rights as a vehicle. And before you can make a human rights claim, you have to first address political economy arguments. And again, Amy does this on copyright as well. She has multiple pieces on copyright, showing that on its own terms, copyright is not the only legal regime that we can use to ensure that there is creation that is not inaccessibly priced. There are other ways that you can come to that. But that is like the next step, right? The first step is to kind of understand what you can do and what you can't do with the language of rights. That's kind of the limited remit of her piece here. And of course, to show again that in some cases, you can actually strategically get some gains using rights language as well.
Right. So I had like a few observations on both the articles that we read. The first one, where she mentions in detail about what the judicialization costs are. For example, in a country like Colombia, judicialization itself in a year, it costs up to like 1% of Colombia's GDP. So reading this article gave me a new perspective about how in current scenario where we define right to health as including right to medicine, it itself is catering to the broader picture of like doing away with human rights, because you are entitled to medicines, all right, but giving very expensive medicines to just like 1,000 people takes away the right of millions of others who would have wanted access to like basic things. So the comment on Amy's article, which is written by, I think, Lisa Forman, she says she agrees in totality with whatever Amy says. But she says that courts in general have given plaintiffs access to expensive medicines as well. But she says the obligation on states is only to give access to affordable medicines. So do you think the courts are going wrong or going haywire in their interpretation of the right to medicines? Because in one observation, it was like only 20 people were given medicines which costed like thousands of dollars. So the courts have to like limit their interpretation of right to medicines and restrict it only to like non-expensive medicines in the current scenario at least. But in the bigger picture, we have to change the market order where medicine, the pharmaceutical companies are charging extremely high amount of prices. There's like one example where I think it's a cancer drug. It was priced at $84,000, whereas the generic was available for $170. So this like completely blew my mind. I didn't have so much information about like how pharmaceutical companies are using like IP rights to expand their monopoly. So this article gave me like a huge new perspective about how you can't view things in isolation. It's necessary to view the economy, the politics of all of this to understand the bigger picture. And then the second article, which is Freedom Now. I think most of the times we all discuss about how the employer exploits the worker by giving him like basic wages, but not giving him conditions of work, good conditions of work. For example, the Amazon case itself, where the time of task is calculated. So people do away with like going to urine or having lunch breaks because it may in the end fire them. So the article mentions that, but then Alex, the author, say the discipline of the market is such that the employee is coerced by the employer, but in effect, the employer is coerced by the market. So if the employer is not exploiting the employee, then he will be wiped off from the market. So both these articles talk about the neoliberal economy and the market order, which are the root cause of most of the problems that we're facing today. Like, these are the two things that I observed from both these articles.
Yeah, I mean, see, the second point you make is a really important one, and and both points are important, but I want to dwell a bit on the second one, because there's a long history to this debate, and the history is that back in the 19th century, there was this big debate because this was when the Industrial Revolution was kind of really taking hold, and the exploitation of workers was massive. Like 16-hour working days, factories were death traps. They were called dark satanic mills by like the English poets, and it was like a horrible situation back then. And so there was one set of like people, one set of like thinkers who basically kind of located exploitation in the context of individual employers who were like these bad people who were exploiting, workers and so they were like, okay, if you just like sort out these bad industrialists, you will get a better situation. The pioneering kind of like understanding there first came from Karl Marx, where he said that look, it's not about the individual, and this is what people who won't. This is the one part of Marxist thought that you wouldn't find being discussed too much. So he makes the point that the capitalist is as much powerless to alter the terms of his or her relationship with the worker as is the worker. Right? So the capitalist has a better end of the deal, obviously, right? But they are as powerless to change that, and so Marx calls it the impersonal compulsion of market relations. And that's interesting is because there is this whole tradition of thought, in legal philosophy and in law, that the infringement of freedom can only happen if there is a person there who is intentionally depriving you of your freedom, right? So if someone is imprisoning you, someone is putting you in like a house, not letting you out, that is a deprivation of your freedom by that person. But if you can't locate like the agency, the individual agency that is depriving you of freedom, then there is no deprivation of freedom. Like then you are basically just like it's something natural that's happening, and so you are unable. It's like something that's bad, but like too bad, right? Like you can't identify who is doing it to you. And the kind of innovation that came in Marxist thinking, and that's kind of the argument being taken forward in the Corey Robin Alex Gourevitch piece, is that there needn't be an identifiable oppressor there for the system to nonetheless be oppressive. And that's also the point that links back to the first piece, because it's not that you have like this one devilish IP firm or like one drug pharmaceutical company that is price gouging. Of course, that is the case. But dealing with them is not going to deal with the problem, because it's not about the individual pharmaceutical company, but about the structure that involves the law and other things that is responsible for all of this happening. And that's why when you're enforcing a right, right? The enforcement of rights always against like a respondent, either the state or like a private party. And the point that both these three scholars make is that entire way of thinking of a right being enforced against a specific identifiable rights violator, right, may not be sufficient to understand the manner in which exploitation happens, which is a function of a specific economic arrangement that has not been brought about by any one person, but is the function of like countless numerous acts of individuals that together constitute that system. So that's kind of like the really core argument in the Freedom Now piece, and what links together the two pieces into kind of like one coherent kind of sort of argument about what the rights framework misses or where it kind of falls short.
I had a observation on this. So on the question of say access to medicines, how do you as a lawyer, as a constitutional actor, say phrase your relief? Because you cannot just suddenly go around asking for a complete overhaul of the neoliberal economic order.
Yeah.
So how do you phrase this relief? Because Amy she does not particularly take a very strong stand on this. And the first response to her piece actually calls her out on this and says that there's actually a lot of progress happening by way of judicialization of medicine.
Yeah.
So since her piece has completely put the thrown the ball in courts of Colombia or Brazil or countries like this, how do you as a lawyer in Colombia or Brazil or India go about these things now to sort of ultimately achieve what she's asking for, short of starting a political movement?
Yeah, no, I think that's a really, really good question, and I think that I think there's no one size fits all answer over there. I think the answer depends upon, as I said earlier, like a very strategic calculation about what you can get at any given time, and so what I mean is this, right? So again, take something like the DU photocopying case, right, which was a straightforward case about photocopying, basically. Now, in a case like that, right, like it's very clear that what's happening is that there is not going to be any larger scale ramification of a favorable judgment framed in the language of rights. So because for many years photocopying has been going on, clearly it was not affecting the margins of these companies. Clearly it's not going to in the future, given what gets photocopied and what doesn't, right? And so like this is a case where you can actually detach the individual relief from the larger structural questions of how copyright keeps knowledge kind of gated and walled up, right? And so it makes sense to actually litigate this in court in the language of rights, because there is actually no broader consequence going beyond the immediate dispute. On the other hand, in the examples she gives about medicine, right, often there is that whole issue. So as she says that in these orphan drugs cases, a judicial order that directs the provision of medicine that is, carries a certain kind of like expense and so on, actually has an effect that's counterproductive. So there you may not want to make those claims in this language of rights in court, because that has larger ramifications about, the political economy as a whole. And so I think that it's a question of, when you are going to court, to make that calculation in good faith and ask yourself that, look, is the relief I claim here, can that relief be detached from the structural problems that this court cannot solve? And will it actually end up entrenching them or not? Now again, that will vary from country to country. So in a country like Colombia, where the court has shown itself to be capable of and actually interested in investigating the political economy structures that are responsible for keeping drug prices high, you can actually go the whole hog and try your luck with like a wide-ranging argument about this. The treatment action campaign litigation in South Africa is a great example of how they framed the relief in a way that would allow them to get what they wanted without risking those harms. So you can do that. In a place like India, say right now, when the Supreme Court does not seem to be capable of or willing to engage in those kinds of arguments, it would be a little silly to try and like do that kind of a thing here, right? So I think it's really a question about, as a lawyer, being aware of how the political economy functions and framing your decisions to go to court or not to go to court. And if you go to court, what relief to claim and how to frame it in that framework, and with the awareness of how that may impact other issues.
So do you think that, moving away from the issue a little bit, do you think as a lawyer you support this kind of judicial intervention for states, for the court to order the government to provide medicines on a case-to-case basis?
Yeah, no, I mean, like, see, this is like a really hard thing to have like a strong view on either way, because on the one hand, if someone is dying for a absence of medicine, and there is somebody who can do something about that, in this case being the court, being the only body that can, ethically, like it just ends up being a very, very bizarre kind of utilitarian calculation to say that, okay, like the court shouldn't save this one person because in the future 10 might not be saved. Like that's just a very strange calculation to make in your head. So it's like, it's on the one hand, it's quite hard to say, okay, like the court should not be doing this. But at the same time, I think it becomes clear over time that this is not a sustainable way for the court to go. And it's like, this kind of intervention may be coming from the right place, but it misunderstands the problem and doesn't solve the problem through its remedy. And so, yeah, I mean, I don't know what the answer is. Like, it's hard to come down firmly on either side. Like, I would like to say that like the court shouldn't, because as I think the piece kind of shows you, just like a blanket order saying give medicine is just not sustainable, because then you can't keep doing it given like the way it's structured, the economy is structured. But yeah, I mean, that's what the ideal would be. But then if there is an actual live person there who requires medicine, like what do you do? I mean, it's hard to just say like, no, not going to, right? So yeah, I mean, I don't think I have like a clear answer over there. It's like a very difficult question.
But will you agree that, I just have one point.
Sure.
Yeah. So will you agree that rights-based approach is the best and only way when you approach the court?
Sorry?
Do you agree that the rights-based approach is the only way for a litigant for making a claim?
Oh no, so I mean, like, I don't think so. So as I said, like, if you look at the Colombian example that she talks about, in courts that are willing and able to grapple with political economic questions, you don't have to limit yourself to the rights framework. In courts that are not willing to do that, I mean, then you have no other choice, basically. But I think what the piece at least makes clear to me is that the rights framework is not enough and can sometimes be harmful. So you have to rethink when you're using it and when you're going to court with it. If you have to go to court, then of course, and if the court is not going to get into like those questions, then your only choice then is the left is the rights framework in that case. But I think the piece kind of tells you sometimes don't go to court. That might be a better like overall thing to do. Just like not to go and not to use that language in the first place.
Hi, am I audible?
Yeah.
Yeah. Good evening, sir. My name is Darshini. I'm in the 4th year. So with regard to the first article, I see that Amy notes the fact that most of the people who go to court for life-saving drugs or very expensive drugs aren't the poorest of the poor. They're just the middle class people, because these are the people who can actually see the litigation case through, right?
Yeah.
So while she does note that there is like a society, like a whole rung of society below the people who are actually going through litigation, the neoliberalist approach doesn't really give an answer or doesn't really have anything to do for this rung of society, because the way I look at it, this free market capitalism is awfully Darwinian in a whole survival of the fittest kind of thing. So even when Neha mentions the full cycle of the market controlling the employee and the employer, and the employer then controlling the employee, I don't think this whole society rung even gets displayed in this circle. So I just wanted to know your views on that.
Yeah, no, I mean, I think that that's the broader critique of public interest or this kind of litigation in that is that it is really dependent on the ability to access courts, to speak the court's language, and to engage lawyers who speak the court's language, and that's often a function of a certain kind of socioeconomic status in society, and so that also means that, for example, the kinds of medicine that you will go to court for will be of the kinds that maybe affect, say, urban conglomerations, and not necessarily the kinds of diseases that are really spread across, say, rural areas and so on. So I think that's a broader issue with the way the courts as institutions work and how they interact with society. So that I agree with. On a different note, although you didn't ask this question, I just want to say one thing, which is that you use the phrase free market capitalism. I just want to clarify that, and some phrase is used all over. There is nothing free about the free market, because it is actually strongly regulated by laws. It is just that those laws are of certain kind. So I mean, the laws of property, right, that determine how market transactions take place, the laws of contract, right, that allocate obligations for market transactions, right, are all kind of constitute the market. So the market is a constitution of law. It's not like this empty space somewhere where people are meeting and engaging in transactions. So it's not free in that sense. It is. I think a better phrase might just be the market economy, because that kind of communicates the sense. And again, there's a lot of clarity on this will come from the Slobodian book, because what he points out is that in the 19th century, and if you go back to Adam Smith and so on, the idea of a free market comes from there, in that the state stays away from the market, right? So you kind of separate the state and the market operates in a domain that does not involve the state. That was the dominant idea of the 19th century, and that's where the term laissez-faire comes from, right? In the 1950s, neoliberal economists were contemptuous of that idea, and they were like, look, you cannot leave the market alone, because the democratic kind of upsurge will ensure that redistributive concerns keep infecting the marketplace. And so basically what you have to do is you have to immunize the marketplace from democratic concerns and democratic politics, and you do that by encasing it in law in such a way that democratic majorities cannot alter that. And you do that through international treaties and so on. In Chile, after Allende was overthrown and Pinochet came to power, they basically framed a constitution, which is called the first neoliberal constitution, which literally prohibited altering the economic arrangements that the market economy. So you could not amend the constitution to take out the market economy from certain domains. So remember that it's not a free market. It's basically a marketplace that is very, very, very strongly regulated by law in order to give effect to the logic of competition in that marketplace. That's just an aside, because I've been reading about it a lot recently. Yeah.
If no one, can I go ahead if no one has a question? All right. So it's interesting that you mentioned the fact that there's no such thing as, free market capitalism, and it it ties in very well with the idea that say Keynesian economics saw that the role of the state was really, really important. And while neoliberals sort of try to completely whitewash that, they really cannot, they haven't really made an argument where the state has completely, say, exited its social function. Am I audible? Hello?
Yeah.
By consigning them to the economy. So I have a comment on the second piece, which is about the state of the Democratic Party. So does that piece not go far enough? Because there is a criticism, particularly by David Graeber, where he says that the focus of the right these days is that everyone should get a job, and the focus of the left
sorry,
is
can you repeat that? Sorry.
Yeah, so he says that the focus of the right is that everyone should get a job. Get a job, otherwise they're useless. And left keeps saying that, there should be more jobs for people. And here, his insight is that he says that Keynes in 1930s said that, by the end of the century, by 2000, we'll be in a situation where you'll have to work only, say, a 15-hour week or a 20-hour week. Right. So is the left in US or elsewhere not aiming high enough when they just say that, there's just unfreedom in these jobs, instead of making a larger case that these jobs need not exist? Because what Graeber says is he says that about 50% of the jobs that we have are, in his words, bullshit jobs. And he says that these have an immense psychological effect on people, because since your job is related to your self-worth, you keep feeling like shit because your work isn't contributing. So on the larger idea, that Tory's piece tries to put forward, do you think it's not ambitious enough? Or
so I think you're absolutely right. I mean, the thing is, these scholars in these pieces are very consciously not making the most ambitious argument that there is, because basically these are all incremental arguments. These are all arguments that I think, in a certain sense, assume that there cannot be a complete overhaul in the foreseeable future, and they operate within a certain kind of a framework, because again, this whole idea that work need not actually be a requirement, again, has its roots in the late 19th century, and this whole sense that once you can deploy technology as it develops in a democratic way, you will abolish most of jobs and you wouldn't need to actually work. So there is that whole abolition of work is like a strong tradition as an argument, and has been there for a century and a half. But I think that these scholars are, they're not making that most ambitious case. They're limiting themselves to like a more modest set of proposals here. I think based on what they think is maybe feasible in a generation or so, and maybe that isn't, according to them. So I think you're right over there. Absolutely.
Sorry, I haven't gone through all the pieces. This week has been a little hectic for me. But this one thing kind of like stuck with me when I was reading Amy's article. So she has emphasized a lot on generics, and she has given examples of, how patented drugs and generics, the margin in the cost that is there. Now, Chip says that drug patents can be overridden, and the terms for compensation and reasonable, whatever those terms are, they can be overridden if it's in a case of emergency. Now, how will this play out in a pandemic? Because as the testing is not even free for COVID, it costs a package of 6,000. And say if one person has COVID in one family, which means the entire family should be getting tested, and the testing itself is extremely costly. So I mean, I don't know how it will play out because courts cannot, provide you any. Any relief. I'm sorry, forgot the word. Yeah, the court cannot provide you any relief. So how should, where will the argument on political economy go with the state?
I think that like there are two different arguments here. Like the point she makes about the emergency is more a point of like patent rights and things like that. So when can you like override patent rights and issue compulsory licenses, things like that. So that's like that's the more an issue of the COVID vaccine or whenever that comes and things like that. The testing issue does not require any of that. Like it's actually much more straightforward. Government can simply can fix a price and compensate private labs for that. So I don't think there is a the testing issue is a much simpler one. It doesn't require the government to like go against any international commitments or breach any international treaty or even invoke an exception, because that is just like a very straightforward thing of a medical process that it's looking at. So I think that the licensing and the exceptions that will come in when the vaccine comes, and if one company
I forgot to add. Yeah. So like what I was wondering was, when the testing itself is so costly, what will happen when a vaccine comes, when it's patented and it's a pandemic? It should be given to almost everyone in the country, and given how poor our population is, how will this ultimately play out? Because I don't see the vaccine to be very accessible economically to people.
Well, I mean, that's a very straightforward thing. Like when the vaccine comes, you reverse engineer it through a generic manufacturer and then issue a compulsory license, invoking like the exceptions under TRIPS, and then have it like manufactured in India. I mean, like that there's a very clear legal path to take there in case of a pandemic. And the Indian patent office can deny a patent, and like there are multiple like legal routes you can take. I don't think that like if the whole exception regime in TRIPS was designed for like things like pandemics, which are like grave public health crises. So I think in that sense, and honestly the whole thing is that to issue a compulsory license and to make sure that the COVID vaccine is affordable is not even a particular threat to the like political economy that frames pharmaceutical like prices, because it is an exception already that everyone accepts. The more your issues start coming in, things like when the AIDS thing happened and all that, which are not so much treated as like a single exception that will begin and end, but like a continuing problem, that has a big scale. That's where like this kind of begins to bite. But for COVID, I think that the legal route is pretty clear and doesn't even disturb the political economy too much, because everyone knows it's like a one-time thing that is not like not a continuing issue.
And also, I think, I have an observation on what Jasta said. Also, in this case, the right of health of an individual is connected to right of health of the society in large.
Yeah.
It is even easier to convince court that you can bypass the patent. And also, there's as I said, that there's an exception in TRIPS agreement for health emergencies like the one we have right now.
Yeah, I don't think the courts will be required for this. It may be, but I don't think this will need to go to the courts, quite honestly.
Yeah. So
hello.
Sorry. Muazzam.
Yeah. No, you sure you can? I can go after you.
No, Muazzam, you go ahead.
Yeah. Hello, sir. My name is Muazzam. I'm in my first year. So I have a small question in the context of what Naomi Klein has written, which comes at the start of the article. That the purpose of human rights basically fails when we treat these acts of abuse, these as simply as acts of abuse compared to the tools that they are to serve the clear political and economic ends. So my question in that context is that isn't it an unfair comparison to make that simply because we treat some litigation as for a single act of abuse, that particular litigation can go on to become a larger policy questions, and then court can it can have an impact on the larger political and economic ends that she wants to compare it with. So is it always necessary to take the this might be the last step that we want to take? Isn't it taking the first step as the last step instead? That we cannot do litigation with particulars, the single acts of abuse, and instead go and look at the larger political questions straight away.
Sorry, let me just reread that quote once. Which is the quote you're referring to?
The purpose of human rights failed when they treated these as acts of abuse compared to tools that they were to serve.
I see what you mean. No. So the thing is that the point is not so much that that you go to court with a single case and then that expands into like a larger issue that can address more things. That's perfectly, like, that often happens, and that's perfectly fine. The critique is about the framing. So you're framing, for example, the lack of access to medicine, right? You're framing it as a violation of your individual right to health that is being deprived because the state is not providing you with that medicine at a rate you can afford. Now, Klein's point and Amy's point is that framing is what misses the crucial issue, that this is not about the relationship between you and the state, which is mediated by your right to health, but this is about the structure of the political economy that the state actually does not have control over, because the state is just one of the many actors that goes towards constituting that. So what they are saying is that you need to re-articulate these issues, not in terms of the right that you as an individual enjoy against an identifiable body like the state or like this one pharma company, but by how the political economy is structured in a way that makes your rights effectively impossible to enforce. So if you reframe the issue in that way, you will have a clearer sense of what the problem is. So to draw that link from the discussion we had about Marx a little while earlier, if you are not being paid your minimum wages, right, you can, of course, and you should go to court and enforce that as your right to a minimum wage. That's very important. But the reason why wages are low across the board is not because of individual oppressive employers, but because if any one employer was to raise their wages, they would themselves go out of business, right? And so the responsibility is not with any one employer, but with the way you have designed the market economy. And so your critique has to be at that level. That's basically what they're saying. So that the two separate issues here. How you go to court and what you get there is one thing, and then as you rightly said, you go to court with an issue and it can expand. The other is a question of how in your own mind you want to frame the problem and where you locate the problem to lie, in a specific actor or in something larger than that. That's what the difference is.
Hello.
Yeah, hi.
Am I audible?
Yeah.
So I had a bit of a tangential question. On the second Freedom Now article, the article challenges the present relation between the employer-employee that is present in the present order. And so what my understanding of this issue is that both Smith and Marx both recognized wage labor, at least, as a form of slavery. They recognize that when you subjugate yourself to your employer to that degree, it's not that different from being not that different from a master-slave relationship. So this, to me, seems a very broad critique of the neoliberal world order. So I just was wondering, when you said that this is not taking the critique to a very long degree or making it too hard or strict in itself, and is a milder critique. What I felt was that it's challenging the very core of what the neoliberal world order professes.
Yes.
And but further, what I basically wanted to ask was, we can see the furtherance of this world order right now in what's happening during COVID. So the UP governments and many other governments in the MP government where I am right now, they diluted the labor laws in those states. So the argument that was given there was that because COVID is there, it is necessary, as is given in the medicine's case, that it's necessary right now that we take these steps, and they ultimately will lead to a greater happiness, to put it in a utilitarian sense. So do you think that in this particular case also, is there any hope of challenge in the courts, or do we just have to wait, as we have to wait in certain other cases, and wait for a new world order itself to emerge, and then we can hope for these changes to come over?
Yeah, I mean, something interesting about the labor law changes, which is that the struggle for the 8-hour working day is a very old struggle that has its roots in the 19th century. And it's often a violent struggle. And one reason why it succeeded finally was because there were studies that showed that the limits of productivity ended around 8 hours. So after that, you're basically getting less return on your employee than for what you're paying. And so the capitalists got on board because they realized that an 8-hour working day is in their interests, and that's what the UP and all governments are trying to roll back. So the bizarre thing actually is that Indian labor laws were never particularly and this is this massive narrative around them. They were never particularly left-wing or radical in any sense. They involved a lot of state bureaucracy, and that was a big issue. But the actual substantive content of those laws is perfectly in keeping with the basic capitalist assumptions. And so when you roll them back, it's not as if you're going back from, say, socialism to capitalism. It's pretty much operating in the same domain and doing things that will ultimately be counterproductive even under a capitalist logic. So that's the funny thing about these labor law changes. I mean, they're not even going from left to right. They're going in some other world altogether that the very capitalist logic kind of is in contravention too. But that apart, as far as the courts go, I mean, I don't know what will happen. There might be a better chance here than in other cases, I think, given the nature of these changes. But I think broadly, ultimately, the struggle for labor law has to be a struggle that's waged in the political domain. It's not something you can win in the courts, because the composition of the courts is such that the issues of labor will never be looked at with a sympathetic eye in courts. And that's like a historical fact. You look at any jurisdiction across the world, you will find the same thing. Your first question about the scope. Yeah, so I mean, the thing is that it's very ambitious in the intellectual kind of critique it makes, and less so in the remedy it prescribes. So this comparison of wage labor to slavery is again a very old critique, and it's the radical character of it lies in the following. You think of slavery as being kind of the legal form that binds one human being to another, right? So the point of slavery is that, well, two things. One is that you are completely subject to the control of the master, and two, you can't leave, right? Now, the point these people make is, if you look at modern day wage labor, when you're in the factory, you're pretty much still under the same level of control, right? Like, you're this whole thing in Amazon, you can't even go for water breaks and toilet breaks, right? So you have a similar level of control while you're in the factory premises. Now, the argument that is made by the capitalists is that, well, you can leave whenever you want, and so there's nothing making you stay there. The point that I think Corey Robin and Alex Gourevitch make is that the really important development that they do, they draw a distinction between exiting from a workplace to exiting the workplace. And they say, look, under modern neoliberal capitalism, you can always exit a particular workplace. Well, not always, but in most cases, in many cases, you can leave a workplace, but you can't leave the workplace. You can't, because you don't have a choice in not working or changing the conditions under which you work. And so that's kind of that's kind of the second way in which they kind of draw the comparison between because there is genuinely no exit option that you have. If you're interested in this, is a very, very interesting piece by G.A. Cohen, who was like a philosopher in Oxford like a couple of decades ago. It's called The Structure of Proletarian Unfreedom, where he talks about how even though an individual worker might, through a combination of luck, effort, skill, rise above their socioeconomic status as a worker, the class of workers cannot do that. And that's kind of like the crucial shift, is that you stop looking at the relationship between the worker and the employer as a contract between two individual parties who are formally equal, but look at it as the relationship between two classes and having different power by virtue of the fact that one class controls the means of production, capital, and so on, and the other class has to sell its labor to kind of like the former. That's kind of the real, that is the actual relationship between the two, and not the formally equal contract that they enter into.
So I had one observation. So in the second article, the authors say that economic decisions, in a sense, are moral decisions. So they give us an example which fits right into the world that we're living in. That is, in the US, where like more police forces are deployed in Black communities, it's a message that the government is sending that which communities do they have a suspicion against, which it's a statement about whom they value. So this is like a new perspective that I thought of, like how any economic decision that a state takes, it affects all of us. And in a sense, the state is sending a signal as to where its ethics or morals lie. And then the question that I had was, in the end of the article, the authors say that the freedom that we enjoy today is not freedom in a sense. It's basically us having a few choices which are forced upon us. So as you move ahead of the income spectrum, you'll get more choices, and your freedom is basically choosing among those choices. So the solution that they give us here is provision of like universal basic income, public health, etc. So this gives people to like focus on other things other than work and enjoy their life better. So in a country like India, will this suggestion work? Or is there any alternative to get out of this definition of freedom that we're living in?
No, I think it's really a question of what is feasible in any given country at any given time. So I think that what works there need not work here at the moment. I think that we are still like in that stage where, given the labor law kind of like stuff happening right now, I think we first have to deal with a much more kind of elemental idea of freedom, which is that basic rights are like not being given. So I think our starting point is like much further back. You have to kind of keep imagining these things and keep imagining what we can accomplish, but our specific actions are conditioned by what at any given time is, I think, possible, which is right now for us quite a low threshold. So yeah.
Any more questions, guys? We have already spent 1.5 hours discussing.
Yeah, I have one final question, if I may. Yeah, sir. So after US blocking the WTO appellate mechanism and going away from the trade systems which are in place for so many years, do you think the right-wing populist politics throughout the world is going to have an effect upon the discussion which we are having regarding?
Yeah, definitely. I mean, there seems to be a lot of like movement towards autarky these days in various countries, and what impact it will have, I don't know. Like it's hard to foresee right now, but it does seem that many of the pillars of the global order from 1950s onwards that kind of maintained a certain, this whole encasement of the global economy from like democratic, scrutiny are under threat because of right-wing leaders being in power. but I think it's still too early to see where that will go. Like nowhere good, but what impact it will have, I think, is still too early to like really know or foresee.
Do you think this is going against neoliberalism or for neoliberalism?
Well, I mean, so the thing is that it's going against a certain brand of neoliberalism, right? A certain version that is encased in the institutions that have been set up after World War II. Whether it goes against neoliberalism as like a concept, I'm less sure because yeah, I mean, like yeah, I don't know yet. Like I probably like can't really figure out what the relationship is at a deeper level yet. At least I can't. I mean, I'm sure people have written on this, but I'm not sure yet.
Right.
I think that's all for the questions. Sir, thank you so much for holding this discussion with us, for spending 1.5 hours patiently listening to our observations or just like clarifying the questions that we have. I think like most of us will agree here that we enjoyed reading the pieces a lot, and it